Hi there. I'm Dr. Suzanne Bechtel, a passionate legal educator dedicated to making legal studies clear, practical, and even a little inspiring. On this channel, you'll find a growing collection of videos designed to help you prepare for the Certified Paralegal exam. It covers key topics, breaking down complex concepts, and offering study tips that actually stick. If you're looking for a deeper dive, check out my Teachable School, where I offer structured courses, interactive tools, and exclusive resources to support your journey towards certification. Watch this video to the end and you'll find a coupon code for a discount. Don't forget to subscribe and explore the playlists. Your success on the NALA CP exam starts here. Now, before we move on to the lecture, there are two important disclaimers. First of all, this is not considered legal advice. Everything shared here is designed to support your learning journey. Also, I am not a lawyer. This course is designed to help you understand the concepts of the exam. This lecture provides an introduction to partnerships. It focuses on the nature of the partnership, the relationship between partners, the advantages and disadvantages of doing business as a general partnership, and the partnership agreement. The goal of this lecture is to help you to become familiar with the following terms and topics. We have the partner and the partnership descriptions, which will be covered. And my little guy Max is behind me. If you hear some groaning, it's just Max probably wanting me to feed him. All right, so we are also going to look at the elements of a partnership, the rights and responsibilities of partners, the advantages and disadvantages of doing this type of business, and compared to other forms of business organizations, partnership organization and management, and how the partnership agreement aids that. The formalities for forming, operating, dissolving a partnership will be covered, and the role of the paralegal working with partnerships. We might also get to some of the resources available. We're going to talk as we move along. There's a slide specifically talking about the Uniform Partnership Act. Most states have adopted it, but several still follow the one of 1914 as opposed to the current one of 1997. This lecture is going to focus on the UPA, Uniform Partnership Act of 1997. And we'll use some references and comparisons to its predecessor sometimes, which was the 1914 UPA. The National Conference of Commissioners on the Uniform State Laws, www.ncusl.org, has the Uniform Partnership Act, both the 1914 and 1997 versions. And partnership law also varies from state to state, so it is recommended that you understand the importance of bringing the law of your state into your discussions on partnership law. However, for the exam, for example, you're going to be looking at the UPA, terms and conditions located there, because that's how the exams work. They take the larger picture that's national and don't really try to fit state law into it because it won't be consistent. So, moving on. So, what is a partnership? A partnership is an association of two or more persons who are going to carry on the co-ownership of a business for profit. All partners of a general partnership, they're considered general partners. Limited partnerships, they consist of general partners and limited partnerships and limited partners. General partners have personal liability for the debts and obligations of the partnership. So looking at the fact that there are general partners and limited partners and what role a particular partner plays, will also have different risks and risks associated with it. For example, general partners having personal liability for the business partnership's debts and obligations. And the partnership can be viewed as both a separate entity and as an aggregate of its partners. We're going to go on to that in a minute here. I thought it was on this slide. Yeah, the aggregate theory versus the entity theory. So a partnership is the totality of persons engaged in the business. So the partnership can be viewed as an aggregate, and then the partnership is also the entity theory. The partnership is an entity separate from its partners. So the people versus the partners, as in people, versus the entity. Go back to that previous slide if this will let me. No, it never lets me do that. Okay. Partners of a general partnership. Okay, so partners of a general partnership are agents of the partnership and other partners. So that goes back to that aggregate theory and entity theory. With few exceptions, each partner may act on behalf of the partnership as an actual authority that binds the partnership to contractual relationships with third parties. However, there are some acts that do require a unanimous consent of partners. And if we look to the UPA of 1914, which is going back to the one that is least used among the states now, because the UPA 1997 is more prominent among the states. But areas that UPA 1914 might require unanimous acts does require, acts undertaken with a third party with knowledge of the act, that would have to be a unanimous consent. Acts carrying on the business of the partnership, the assignment of partnership property, acts to dispose of the goodwill of the business, carrying on the business of the partnership, make it impossible, you'd have to have a unanimous consent for that type of decision. A few others, but this 1977 relies more on provisions in the partnership agreement than it does what's in the 1914 UPA. The UPA 1997 provides that the unanimous consent is required for acts undertaken with a third party who has knowledge or has received notification that the act is not authorized, acts not apparently undertaken for the purpose of carrying on the ordinary course of partnership business, amending the partnership agreement, unless it's already been provided for in the partnership agreement. So in 1997, you realize the agreements and the UPA 1997 will kind of overlap and complement each other in some cases. And if a limited liability partnership status is wanting to be adopted under the 1997 UPA, it's required to be by unanimous consent. Okay, so any states that follow the UPA 1997 with regard to consent issues, the partnership may file a statement of authority with the Secretary of State or other appropriate state officials. And this will give the public notice of the authority granted or denied certain partners. So it's a public observation of the authority granted or denied to certain partners. And persons transacting business with the partnership, they're not necessarily deemed to know there's a limitation of authority because it's in the filed statement. So there's public knowledge. A statement of denial can be filed by a partner or other interested party to contradict information, including in the statement of authority. So a partner, this is per the UPA 1997, the partnership may file a statement of authority with the Secretary of State. However, the statement of denial can be filed by a partner. And so the full extent of the personal liability of partners can vary, and it can depend on state statute, it can depend on the partnership agreement. But generally, partners have joint and several liability for all debts and obligations of the partnership, and creditors can look to the personal property of the individual partners to satisfy the partnership's obligations. All right, so when we have part owners have own property, partnerships own property. Okay, so two ways of looking at the rights of the partnership the individual partner's rights in partnership assets, or otherwise partnership property. When a partnership enters into agreements with third parties, the agreement includes provisions specifying the limitations of each partner to act on behalf of the partnership. But under the UPA 1914, partnership property is held in a tenancy in partnership type of ownership. And this means that each partner has an equal right to possess specific partnership property for partnership purposes, but has no right to possess such property for any other purpose without the consent of the other partners. However, under the UPA 1997, where the property is treated, it treats the partnership as a separate entity. So partnership property is owned by the partnership, not as tenancy in partnership. And the individual partners own the right to receive income or profits from the partnership property. And a partnership's right to receive income or profits from the partnership property, they can be transferred. And a partner's right in specific partnership property is generally not assignable under the 1997 UPA. So the state statutes and partnership agreements generally grant each partner the right to have a separate account. And this account is what reflects their contributions, share of the gains, and share of the losses in the partnership assets. Partners are granted by statute the right to an equal share of the partnership profits unless it's amended by the partnership agreement. And partners are also responsible for a proportionate share of the partnership's losses. So this separate account is designed with the properties of illustrating their limits in liability or their limits in asset to compare to liability later. Unless it's specified in the agreement, though, partners can be repaid contributions and to share equally in the surplus that remains after partnership liabilities are satisfied. So partners also have the right to get reimbursed for certain money they spend on behalf of the partnership. They have the, unless otherwise specified in the agreement, so anytime think about the agreement can say something different. The UPA certainly drives this ball, but like I said, there's an overlap sometimes with partnership agreement, and one can outdo the other. So each partner has a right to share equally in the management and conduct of the partnership business, and the agreement can also provide for a managing partner or a committee to oversee the management of partnership. Partners are granted, and this is a statutory observation. Their access to the books and records of the partnership, and partners are entitled to reasonable compensation for their services in winding up the partnership, what else? State statutes and partnership agreement may provide that each partner has a right to have his or her partnership interest purchased from the remaining partners after permissible dissociation of the partner from the partnership. Sounds like a psychology class whenever I read dissociation. Okay, going into the duties and dealing with each other. So this is something where we find state statutes and partnership agreements provide for what partners owe to each other and the partnership. Their duties generally include contributing toward losses, a duty to contribute toward losses that are sustained by the partnership, and that's according to each partner's share in profits, unless the partnership agreement provides otherwise. And they have a duty to work for the partnership without pay unless there is remuneration provided for in the partnership agreement. They have a duty to submit to a vote for the majority of the partners when differences arise among them. And they have a duty to provide information to the other partners concerning the partnership. There is a fiduciary duty that partners owe to each other. Under the UPA 1997, there specifically states that the fiduciary duty partners owe each other includes the duty of loyalty and the duty of care. And those two terms are defined under the UPA of 1997. Okay, so advantages and disadvantages of doing business as a general partnership. Compared to other types of business organizations, the advantages such as partners having flexibility in managing a partnership. This also includes the ability of all partners to participate in management. Partnerships are subject to fewer formalities and they have less regulatory and reporting requirements than corporations, which we'll learn about in another lecture, especially publicly held corporations. The cost of organization of the partnership is relatively low. It's, especially compared to things like other types of business organizations. They're not required to be filed at the state level, so there are no filing fees that are assessed. The flow-through income taxation of the partnership is really one of the biggest advantages the partnership offers over most other types of business organizations. So compared with sole proprietorship, partnerships generally have diversified capital resources because there's more than one owner involved. The disadvantages, though, are many. You see the list is a little longer than the advantages, but some of the disadvantages include partners are generally personally liable for the debts and obligations of the partnership, and compared to corporations, partnerships have very loosely structured management criteria under the state statutes. Unless the partnership agreement is worded very carefully, it can be difficult for the partnership to take action, especially in situations where there are disputes among the partners. So that's the importance of having a partnership agreement. Compared to corporations, which have stock that are freely transferred, partnerships present a lack of business continuity, and it's difficult to transfer interests of partnerships. Compared to corporations that can raise capital by selling stock on the open market, partnerships have a limited ability to raise capital that will help to run the partnership business. And compared to sole proprietors, partners may incur significant expenses in organizing their businesses. And this is mainly due to legal fees to draft partnership agreements. All right, management and control of the general partnership. So unless it's otherwise specified in the agreement, sorry for that interruption. My dogs got a little upset with each other. So back to organization and management, management and control of a general partnership. Unless it's specified in the agreement, all the partners will have equal right to manage the partnership business. And it can be managed by a designated managing partner or by a management committee. And if there is a dispute, decisions are made by a majority of the partners, unless there's some other method of resolving the dispute that's been agreed on. All right, the agreement. This is an important part of the legal professional's role in helping businesses do their startup. A partnership can be formed orally, so there are no formal requirements, but is recommended, a partnership agreement exists. The words partnership agreement have come up over and over and over, unless the partnership agreement provides ... So all partners would enter into the partnership agreement. So it's considered the law of partnership unless any terms, basically the law of partnership, common law, UPA, that sort of thing, unless those agreements are written to show something contrary to the law. So there is a huge importance to a partnership agreement once again. Partnerships also have financial structures that are apparent to partnerships. The partnership capital consists of all the assets of the partnership and includes the contributions of the partners and the undistributed income earned by the partnership. And unless it's provided for in the partnership agreement, partners will share equally in the profits and losses of the partnership. And the partnership agreement can provide a different formula for sharing the profits and losses. And if it does, there are 3 criteria. The amount of the initial capital these losses will be based on. So this is in profits and losses, and their formula can affect the amount of the initial capital contributions. A formula might add additional capital contributions or services rendered on behalf of the partnership by the individual partners. So this equal share of partnership profits and losses can be affected by those three terms. Okay, partnerships, like every other business, may need to dissolve, and if they do, there's a dissolution, winding up, and termination of the general partnership strategy, and how the laws affect that. If we're dealing under the UPA 1914, whether one partner quits a partnership for any reason, the partnership gets dissolved. So one partner gone. Under the UPA of 1997, though, one or more partners may dissociate from the partnership without causing the partnership's dissolution. So that's a unique difference between the two, 1914 and 1997. A partner's dissociation can be caused by agreement, by statute, or it can happen from wrongful activities. Partners who dissociate from the partnership contrary to provisions in the agreement and or contrary to state statute, they'll cause a wrongful that's how you cause a wrongful dissociation, and there may be liability to the partnership and other partners for damages caused by wrongful dissociation. Let's see, winding up. In most instances, when the dissociation is not wrongful, the dissociating partner has the right to have his or her interest in the partnership purchased for a buyout price. And again, the partnership agreement would be a way of managing that situation. Under the 1914 UPA, some acts cause a partnership dissolution automatically. Expiration of the term of the expiration of the term or completion of a particular understanding, undertaking that is specified in the partnership agreement, the express will of any partner. Again, we're under the 1914 UPA. That's again the will of any partner when no definite term or particular undertaking is specified, and the express will of the partners who have not assigned their interest in the partnership. A couple of others: bankruptcy, death of a partner, order of a court. Under UPA 1997, the dissolution would take place when there's a notice by a partner in a partnership for a definite term, when there's since the partner's dissolution, 90 days has passed, or by death, or otherwise through wrongful dissociation, unless a majority of the partners want to continue with it. And there's an express will of all the partners to wind up the partnership business. And in the event the partnership agreement provides for a winding up of the partnership at a certain point. If it becomes unlawful for the partnership business to be continued, let's say it's a partnership to handle medical marijuana and it's been outlawed, then we wouldn't have the same business going on anymore. Example of that. And then the court can make a determination to dissolve the partnership. So the winding up also, when there's a winding up, the partnership agreement can be consulted. But once the partnership, upon dissolution of the partnership, that's when the relationship terminates and then the winding up process begins. This means distributing the assets of the partnership on dissolution. They're usually in the partnership agreement. However, these guidelines can't violate the statutes of the partnership's state of domicile with regard to distributions of the partnership. The debts and obligations of the partnership owing to third parties need to be paid in full. So that happens before partners are paid any portion of the respective profits. The partners must contribute to the assets of the dissolving partnership to the extent that it's needed to meet the financial obligations of the partnership. And in states that follow UPA 1914, all non-partner creditors must be paid before the partner creditors can be paid. And in states that follow the 1997 UPA, the assets of the partnership must first be applied to discharge the partnership obligations to creditors, including partners who are creditors. So basically, creditors have protection under the UPA. Different protection exists under 1914 versus 1997. If any of, it doesn't have to be all of it, but any of the partners are insolvent or unable to pay their share of the partnership liabilities, that partner's share must be paid by the remaining partners. So it's a little bit of a risk, and then any partner who's required to pay in excess of his or her share to settle the affairs of the partnership, they have the right to enforce contribution of the other partners, pursuant to the statute and the partnership agreement. So that's general partnerships in a nutshell. There are other types of partnerships. Joint ventures, they're very similar to a general partnership. They're not identical. The joint ventures are usually formed for a single transaction or an isolated enterprise that would be happening. There are limited liability partnerships we're going to talk about, and we're going to talk about limited partnerships in our future lectures. The paralegal's role, I think there are 2 slides on this. We keep abreast of the partnership laws and what the filing requirements are. I think paralegals would mostly use resources such as legal form books, state statutes, and information from the Secretary of State's office and the state where they're located. They'll assist with drafting partnership agreements, working with getting certificates, drafting statements of partnership authority. We talked about that early in this lecture, and maybe a statement of denial of partnership authority. Other tasks, drafting other documentation about consent issues, organizing a method for retaining partnership records, and assisting in preparing partnership tax returns, and of course assisting if any wind-up takes place or dissolution of the partnership. So that is our general partnership lecture. And we'll move on to another type of partnership in the next one. Thank you. I hope you got some good information from this video lecture. Don't forget that I have a Teachable school account. Here is the address for that, mayananda-s-school.teachable.com. The name of my school is Mayananda. And also there's a coupon here for you to save some money. And finally, good luck on the exam, and don't forget to like, share, and subscribe.